This goes to presidential immunity, and at what point does that immunity fall and you can bring criminal charges against the president for acts that they may have taken during office, which means, Dad, you would then have to start defining what is an official act by the president, what is a pseudo-official act, and then what is a non-official act. So like all these different ranges. Yeah. And that's courts don't love doing that.
They even have a third category of on the periphery. And that's actually a legal standard, the periphery of presidential responsibility. So what has happened is the president's lawyers moved yesterday for an application for a stay of the D.C. Circuit's mandate pending the filing of a petition for certiorari. Now, what that means is this. The D.C. Circuit said that there was no presidential immunity, and they gave the president until yesterday to file an action with the Supreme Court. If he did not, they were going to return the case to the district court, who would then proceed to trial probably in April or May. He did file. The president's lawyers did file. They are making. It's an aggressive move in the sense that I would have focused narrowly on the mistake of law that was made was allowing immunity to expire when the president leaves office, would set every living president up for litigation for the rest of their life. Instead, they took a more broad approach, saying absolute immunity. I was saying, get a ruling that says, hey, the Court of Appeals was wrong when it said the immunity expires when the president leaves office. The rule is it continues. Then you have to make a fact finding as to whether the actions taken by the President Trump, were within his official activities, or at least on the periphery of those activities, or those that aren't, divide those up. That's not what they did. They went for a very absolute immunity approach, which I think is a little bit of a tougher standard. On the 20th of February, Jack Smith's office has to respond to the application for a stay. Right now, the proceedings are stopped. Nothing is moving forward while this pens. My guess is Jack Smith probably responds earlier, but Jack Smith's office has been trying to leapfrog over the normal appellate process, because normally when you lost the three-judge panel, the case stays in place, and you go what's called en banc. You request the entire court to hear it.
What the president is saying is that unless you take it, the president would face the threat of indictment by an opposing party after changing administrations. I'm reading from the brief.
Here's the contra argument. Here's what some appellate lawyers are saying, and this is where it gets a little confusing, but I think people need to understand. Some lawyers are saying the case should go to trial. The facts should be put forward as to what he actually is accused of doing, what acts he took. There'll be a trial. There'll be an adjudication of guilt or innocence. Then it would go to the Court of Appeals to determine whether the immunity question should have been addressed with official acts or not, and then to the Supreme Court.
If you look at the U.S. Attorney Manual, that specifies it not within 90 days of an election.
So the election is November 5th. So you'd go back October 5th. Then you'd go back to August 5th. Then you go back September 5th. If the trial did not start until July, which is now they're saying the earliest it could because March is off, it would go all of July and all of August. Boy, you are right up to that. Right up to it. What do you think happened? What do you think Judge Shutkin does?
I think Judge Shutkin does not try this case.
I don't either.
In 2008, the Attorney General put out a memorandum, which is still the rules today, about do not time your investigations to affect an election.
So and it's normally a 90-day rule, but we're in a general election now. Is it fair to say that even now it's tainting the election?
Yes, it is.
Don't you think, Jordan?
Oh, absolutely. It's tainting the election. I mean, President Trump is outside and inside courts all over the country all the time. He's already had to go all the way to the U.S. Supreme Court once in Colorado because they tried to kick him off the ballot in 14 or 15 states, and there's a dozen more that would like to. He's got it in Georgia. I mean, we wouldn't know about Fani Willis and all these different issues she's facing if it wasn't for President Trump and the number of people she tried to indict there with her now boyfriend, I guess, and that investigation going on. I mean, and then the Jack Smith dueling investigations, both in Washington, D.C., and don't forget the classified documents.
What the court below basically said is the immunity doesn't stay with you. It doesn't travel with you. And you've probably discussed this earlier, but it's the fact that is just shocking to me. Of course, a president's immunity for official acts he did while he was in office is going to travel with him.
It should.
Even once he's out of office, you have to have that protection.
It's interesting, though, they did not. I would have led with that. And my question, that would have been my first question presented. They didn't do that here. They went right to absolute immunity, which may be a strategy of trying to eliminate the case altogether, where I would have said, hey, do it in a two-step and delay the time, but
Right. And I think, like the court acknowledged in the 14th Amendment case, that, hey, if we let one state decide this, it's chaos. I think it's the same kind of deliberation here, is that if you don't let that immunity travel with the president, that's going to be chaos. And we've said it before. Obama, actions that he took, people can come after him criminally. Actions that Biden has taken, once he's out of office, people can come out after him criminally. That is going to be chaotic.
It's important to keep in mind that the president is immune from prosecution for acts that are committed in the furtherance of his presidency. So he's empowered to act in a discretionary manner, and we don't wish to hamstring future presidents with respect to a limited decision that is coming from the Court of Appeals. So I think you're right.
Slow it down.
Slow it down. Let the Supreme Court take some time, consider this particular case, have a full factual record, and then decide.
Send it back down to the Court of Appeals and let them petition for a rehearing en banc. If that's denied, then go for a cert petition and a stay at the Supreme Court like you would in any other case. Rushing these, I don't think helps anybody in this situation. It doesn't help Jack Smith. It doesn't help the body politic.
You're never going to be able to have a clear line test on what's an official act and what's not. There are some things you could say, that's official always. That would never be official. But there's a whole lot in the gray area. And because there's a whole lot we don't know about decisions that presidents have to make. On purpose. So courts having to get involved in that, they don't want to.
Well, there's even law about them not getting involved in that, second-guessing a president's decision-making process on official acts.
But if they feel like a president is about to be unconstitutionally prosecuted because their rights of having this immunity so that they can have these frank discussions with their advisors, I think that is where the courts have the proper role to step in. And listen, Jack Smith was so concerned about this, he brought this case first on his own to make sure his cases didn't get thrown out. You've got to balance this along with all the elections and with, of course, primaries coming up in South Carolina, and then, of course, Super Tuesday, the Supreme Court case last week, and now back at the Supreme Court this week, which we could learn a lot by the end of the week on what happened on the 14th Amendment.
The Supreme Court could also say, we're not going to hear it now. We want it to go back to trial. We want it to go to trial. We want to see what the facts that are proved are, then make a determination as to whether those were official acts or not, then go to the Court of Appeals, then go to the Supreme Court of the United States. The only thing there is that at that point you would have had an adjudication of guilt, and that goes to Andy's point of, is that interfering with an election? Are we close enough where it's interfering? And technically, it's got to be 90 days out, so that would be
pretty close.
August, be really close by the time you try it. Yes.
Especially because the 90-day out rule, does that start when people can early vote now? Because you could add that almost like the 120-day rule.
True.
That's true.
In many states. I mean, I think, it starts getting too fishy for a true democratic
I think it already is.
republic.
I think they'd be better off putting stays on everything.
It's why Jack
Go
Smith
have an
tried to
election,
jump over.
see who wins, and then adjudicate it out. If Trump wins, obviously these cases go away.